George, it's so nice to get you in the office on a Saturday.
What do you mean? I'm always here on a Saturday.
I know. Well, George, I've been doing this for 35 years, and Saturdays are still part of the routine.
I like Saturdays because they're a free day without phone calls.
Right. I like Saturdays because it gives me an opportunity to spend extra time. I'm very big on, if someone said to me, what is the most important thing in a case, whether it's a civil case or a family law matter, is preparation. Mm-hmm. I believe that you need to review the facts again, review the facts with the law, review the facts with the client once, review the facts with the client a second time, talk to them before court and say, are you prepared? And then be prepared for court. I normally get so prepared. I actually prepare all my questions, get to court, and then it just flows. To know the facts as if you were a party, as it's your family law matter, was what makes a big difference.
Yeah, I do the same thing where I end up writing out all my questions, and then I take my questions and turn them into bullet points because you can't read the questions. And then I end up not even using the list anyway, except at the end I go through and check to make sure I hit the major points that I wanted to hit.
I think one of the things when I have a client, a potential client that comes in and they say I have a custody matter, of course at the potential new client consultation, I just want to get general information. I always say I'm a nosy neighbor. Mm-hmm. You know, a general information. I want to tell them a little bit about the law. The standard in Pennsylvania, I want to say, the standard is best interest. Mm-hmm. And a lot of times that needs more detail. But after the consultation, and the reason I think the consultation is important, so many people hire the first lawyer that they go to see, and I'm not an advocate of that. I don't let anybody hire me the day they come to see me. I tell them to interview other lawyers because all of us lawyers out there can tell you that the standard in custody cases is best interest. What makes the difference between a client who feels that they had a custody case that they were heard and was successful, and success doesn't necessarily mean getting everything that you want. But what makes the difference is being able to communicate with the client, with the lawyer, understanding the facts. Once they hire me, then we really take a deep dive into all the custody factors. Questionnaires that they need to fill out. I want to know their family life story like it's my family life story. And then we want to put it to the facts. And, the courts are really turning toward, this nucleus of co-parenting, sharing custodial rights. When I started practicing law 35 years ago, the family dynamics were different. Mom stayed home, or one party stayed home, did the cooking, the cleaning, the laundry, the childcare, and the other person worked. Normally it was one household working, mm-hmm. and it was completely different, and the person that was working didn't really have time. Families have changed now. Moms are working outside of the home. Dads are working outside of the home. Dads are contributing in the house. Moms are contributing to the house. And that makes the analysis of the factors really completely different. And really sitting down with your client, I would say on an average, when I take a custody case, I've probably gone through the custodial factors at least 5 times with the client. Once at the potential new client consultation, once when they've hired me and we're going over the questionnaire, once when we're preparing for court at least a month before, once when we're actually preparing for trial about a week before, and then even the morning of trial, touching on a few things, because a custody case, while all of the, what I like to call the fluff witnesses are important, hearing from the grandmother, who of course is going to say that their grandson or granddaughter is a good parent, mm-hmm. hearing from the neighbor, those are what we call filler witnesses. Custody cases normally turn on what the mother and father are going to say. And one of the factors, very important factor to be considered, is the children's wishes. Now, the children's wishes have to be reasonable. I had a case once where the child testified that I want to be with mom. And when we flushed it out, mom had been out of the child's life for 4 years, but had just recently come back. But mom bought the children ATVs. Mm-hmm. Mom promised the children a trip to Disney World. Mom had no rules. Oh, God, I want to have ice cream every day. But that's not in my best interest. So typically, if another case I had where the child was 7 years old. I was so impressed. I wasn't even sure a 7-year-old should be interviewed by the court, but it is a factor, and of course the court it did. And I remember the child was so small that it was sitting on a chair and could swing its legs on the chair.
Couldn't touch the ground.
Couldn't even touch the ground. And the judge was so great in this case, and that she said, you know, what do you like to do with mom? Child answered. What do you like to do with dad? Child answered. And the judge said something like, if I had a magic wand, how would you explain the current situation and how would you like to change it? And I was like, wow, that's a good question. And the child paused for a minute and at 7 said, well, you know the teeter-totter at the playground?
Yeah.
And we're all sitting there, we're saying yes. Well, when I'm on the teeter-totter with Billy, I don't move. Billy's a lot bigger than me. Judge, he said judge, which I thought was funny. But when I'm on with my sister, we go back and forth and bounce. And that's how I'd like the time with my mother and father. Opposing counsel, myself, we all stopped. We looked at each other. After the child left, we're like, was that the most intelligent?
Probably the wisest thing a 7-year-old has ever said.
Ever said.
In open court, with a judge. You know, attorneys, we feel the pressure.
Right.
And the clients aren't experts at testifying, so they say wild things sometimes. But a 7-year-old, you know that saying, the kids say the darndest things?
Oh my God, it was a perfect thing. And what was interesting is most of the Northeast counties, the judge will either ask the mother and father to leave and interview the child with the lawyers and the judge, or they'll ask we go in chambers. Sometimes the judge will ask for questions ahead of time, and we even as lawyers don't get to participate. And I like the standard, and it's very important so that the kids feel. Most of the judges in Northeast PA will say, mother, father, don't ask the lawyers what the child said, you know, other than saying the child did well, child loves both of you, because we want the child to be candid and not pressured. And of course, the funny thing is most of the children share. I know in this particular case, both the mother and father heard about the teeter-totter thing because the kids shared it.
Yeah.
I mean, because you're right, kids do say the darndest thing.
That's amazing. What happened in that case? What would the judge rule? If you remember.
Yeah, I do remember. In that particular case, the mother was trying to get sole legal and sole physical custody, and the judge awarded shared legal and shared physical custody on a 50-50 basis.
Wow.
And in that particular case, I think they rotated every week.
Why was mom, if you remember, seeking, you know, what I call the strictest of the custodial arrangements? I want everything, and the non-custodial parent can have visitation or very little control.
I think the situation is that the mom had more of a older mindset, and she just was of the opinion that
the children should be with mom.
Yeah, the children should be with mom, and my assessment was the factors weren't covered very well with her, because to get primary physical custody is very difficult. I mean, you have to think about the scales of justice, and this is what I like to say. And in the scales of justice, the lady is blind and the scales are even. And the court will put the mother on one side and the father on the other side, and then go through all of the factors. And, you know, what does mom do for the child? What does dad do for the child? What is mom's time? What is dad's time? And if the scales weigh evenly, and in this particular case, they would have weighed evenly. They were both great parents. Then I think you have a duty as a lawyer to tell the client the likelihood is this will be a shared physical custody arrangement. Now, have I had cases where it shouldn't be shared physical custody? Many. I mean, there are times where a child is with the parent and the parent is out drinking, or the parent is using drugs, or the parent is not parenting, or physical abuse. And, you know, a lot of issues on corporal punishment nowadays. Because the funny thing is with corporal punishment is I'm old. So at 61 years old, trust me, my parents used corporal punishment.
Yeah.
However, today's time, there's a belief that there are lots of other ways to discipline. You know, time out, taking an item. So while there isn't a law that says corporal punishment is illegal, I mean, obviously it's illegal to abuse. But if you tell a child not to touch something and you tap his hand, technically that's corporal punishment. But I think you have to weigh that. I see more and more shared physical custody cases than ever before, and I'd like to believe it's because parents are really coming up to the plate.
Why do you think family law matters, and maybe even specifically custody, is so expensive?
It's expensive if you want to make sure that the client understands the process. I mean, I think you can have an inexpensive family law case if you don't care. You don't want to go over the factors. You don't want to learn the facts. You're not going to be well prepared. But I think family law, to do it well, requires a lot of work. It requires you to become an intimate part of your client's living, your client's facts, knowing everything that goes on. Give me what happens in a day through school. Give me what happens in a day on the weekend. What do you do with your children? What's happening at doctors, dentists, extracurricular activity? Who are their friends? Who are your friends? To do it well, it's expensive because you need to prepare well. And I also think it's expensive because there's a lot of possibilities for special relief motions, things that we're not prepared for. Mother and father both have a medical marijuana card to use cannabis, and all of a sudden you're facing an emergency petition because one party's smoking cannabis.
Yeah.
Mother has diagnosed and treated mental health conditions, which she's had, and all of a sudden emergency petition, and now you have to get the medical records and defend that. Child's late for school a couple times, and you're facing a truancy issue. So I think a lot of family law, there we have PFAs, and PFAs are protection from abuse orders, which are out there to protect both the male and the female from any type of domestic violence, physical violence, or threat of physical violence. And it's a very simple rule we learned when we were in kindergarten. Don't hit and don't threat. Mm-hmm. And the courts take that very seriously. Don't hit and don't threat. We can have the most litigious divorce where we're having a debate over all of the economics, all of the finances, but don't hit and don't threat. I mean, it's very simple. And if you do that, if you push, shove, or hit someone, the person can get a protection from abuse order. And if you threaten, I had a case once where the party wouldn't hit or push or shove, but there was a post on Facebook of a deer with a thing that said, "Wish it was my wife," had guns, and he had threatened guns in the past.
What did the court do in that situation?
They granted the protection from abuse. It ended up being a consensual protection from abuse.
So you entered into an agreement.
Because you have to be practical. I mean, I always tell my potential client, how would you want to be spoken to? How do you want to address this matter? That's how you need to speak to the other person. And sometimes, listen, I understand. No one ever gets married thinking they're going to get a divorce. No one ever has children thinking the nucleus of their family is not going to work. So what happens is, it's emotional.
Yeah.
But maybe instead of being reactive, you need to step back, go for a walk, come back, reassess, or talk to someone. Some of my most prepared clients were the clients who recognized that there was a situation and came for a consult early. Okay.
When you said talk to someone, do you mean an attorney or also maybe like a treating psychologist or a psychiatrist? Because I've had individuals come in and they need to go and talk to someone for whatever they're dealing with or allegedly dealing with, but then they raise the concern that the other party is going to subpoena their psychiatrist to get all of those dirty facts so they can use them later.
Medical records are protected. So you can confidently say to a client, it is very difficult to get someone's mental health records. You could, in a custody case, request someone go for an independent psychological evaluation. However, there has to be grounds for that. You just can't maliciously request it. And not to mention the fact that it's very, very expensive. But there's actually, your medical records are very hard to impeach and are protected.
Okay, so you could get them.
You could, but it'll be difficult.
Is our family here?
Hello.
Hi.
Hi guys, we're doing some videos.
Yeah, don't mind us. Come up and say hi. You know, in regards to the cost, of course, no one gets married thinking they're going to get divorced later. Why would you get married in the first place? Why don't they just enter into a prenuptial agreement? Why don't we see, at least in my practice, I've seen very few prenuptial agreements and a ton of divorces, not the other way around.
Well, I'd like to believe that I think people don't think about prenuptial agreements because when you're in love, you're thinking with your heart. You're not thinking with your head. And, you know, you're in love and you don't think about it. But the fact of the matter is, I'm a big advocate of prenuptial agreement. A prenuptial agreement sets out all of the parameters so that divorce, if you end up getting a divorce, isn't going to be so difficult. And good prenuptial agreements are negotiated months before marriage, are taking care of both the parties and addressing many factors, addressing, you know, what happens after 1 year, 2 years, 5 years, 10 years, and are fair. And I'm a big advocate of prenuptial agreements. I'm an advocate to postnuptial agreements where you get married, you realize it's not working, you don't want a divorce, you're going to try marriage counseling. Well, let's address these issues now. And it's not as common as it should be, and I'm surprised.
What do you say to someone where one potential spouse wants the prenuptial agreement, but now they're nervous that if they present it to their soon-to-be spouse or whatever you call it, you know,
Their fiance.
their betrothed, that this will blow everything up?
What I say is that if that blows it up, then it really wasn't meant to be. Because if you can't speak with your potential spouse about finances and the need for a plan and how we're going to protect each other and how I'm going to protect you as the wife and how I'm going to protect me as the husband and how we're going to protect what we grow together, then my opinion is that isn't a marriage that you should be entering into.
Yeah, that's fair.
Yeah.
I think just from the cost perspective, I mean, it costs you maybe a few $1,000s to get a prenup, but we've seen divorces $40,000, $50,000, $60,000, if not more. They can save so much money if they can iron out a lot of their issues before they sign the legal document getting married, than potentially risking it all later. And then, of course, we have all the assets that they've accumulated during the marriage that now are at play, and they're going to fight tooth and nail over that.
I think the cost of a prenuptial agreement depends on the work in a prenuptial agreement, and the work in the prenuptial agreement depends on the assets, depends on the goals of the parties, depends on, you know, are we having children? Are we acquiring businesses? Are we acquiring assets? What's the wealth deviation between the parties? Preparation. So
Can you deal with children in prenup? I didn't think you could.
you could deal with maybe plans for, if I have clients who share different, they have multitude of houses, they spend time in different houses, they, you know, obviously if you had a prenuptial agreement that said if we ever have kids, we're sharing custody, that would be that's great. However, that can be changed. So one of the things I want to tell you in a custody case, which is sometimes a little frustrating for a client, you know, I have a custody case, we have a rare case where one party wins primary physical custody. The children are going to spend most of their time with, let's just say, dad.
Okay.
What's very shocking is that you have to tell your client, custody isn't like a contract dispute. The judge decides it and it's over. Custody is something that can be looked at by the court when there is a change of circumstances or when there are facts that you believe you can present that makes the court be compelled to believe this change is in the best interest and welfare of the children. And when that's said, I have cases where we're back in court every other year. We're back in court every 2 years. And so you can never rest on your laurels. And I guess that's a good thing in the Commonwealth of Pennsylvania because it makes parents be better parents.
Yeah, be proactive.
Be
towards
proactive.
parenting.
Yeah, exactly. So if you had a prenuptial agreement, turning back to the prenuptial agreement, that tried to address
Custody.
we're going to have a great nucleus, we're going to share custody, we're going to, this is our plan, even though we're if we get a divorce, we're still going to spend 6 months in PA and 6 months in Florida.
Whatever, yeah.
We're still going to keep the private tutor. Let's just say that's the circumstances. But the fact of the matter is, either the husband or the wife, as it applies to custody, could petition the court to change that.
Could it be? It's an enforceable custody agreement as long as it's in
Oh yeah,
writing?
it's enforceable.
Can it deal
but
with
it can be
support?
changed.
Can it deal with support as well?
Support, as long as it is based on the income. So you can't, how could I give you an example? You can't say no child support. A prenuptial agreement can't say, well, it could say it, don't misunderstand.
But it won't
me.
be enforced.
It won't be enforced. You
Yeah.
could have a prenuptial agreement that says if we have children, there will never be child support.
Yeah.
However,
For one
that will
parent, the paying parent's gonna love that. Yeah.
However, the fact of the matter is that's not enforceable. You can't waive away child support. It could be considered. So, say we've done an analysis of income and we already know what the husband's making and we already know what the wife is making and we already know what the projected income is, and say we already have children. We could then do an analysis and say this is our projection for child support and this is the projection for the increased earnings, and we can certainly have a projection because remember, child support is not for the husband, it's not for the
It's for the child.
wife, it's for the
children.
child. It's to make sure that the child isn't financially suffering because they're not in an intact family anymore.
Have you ever had a situation where a parent receives child support, whether by agreement or order of the court, and then the parent who is receiving the support is using the support payment not for the child?
They can use the support payment for whatever they need. A support payment.
What if they go use it to buy clothes for themselves and take themselves to
The
dinner?
court doesn't modify that, doesn't monitor that. You
Okay.
can use that for, you could use it for light, heat,
But what
child's
What
activities.
if you know the parent's using it for their own personal gain? Can you do anything about it?
I have never seen a case where you could do anything about that. Yeah, it's their money. And maybe going out to dinner is to the child's best interest.
Okay.
Yeah.
Yeah, that makes sense.
Yeah.
Yeah. What else? Is there one most important custody factor?
No, all of the factors are weighed equally by the court.
And you've given me many custody orders to review, and it seems like the court goes one by one and then does that balancing test. Does this factor weigh in favor of mom? Does this factor weigh in favor of dad? Or is it a neutral factor?
The court is obligated to weigh all the factors, and actually I had an appeal where the court didn't weigh the factors. I had an appeal where the court issued a mother has primary physical custody, father has every other weekend by the court and signed it. No analysis, no anything.
Okay.
That was appealable and sent back for analysis of the factors.
Now, like if you look at the factors, and there was 17 or something.
Yeah, well,
something like
there
that.
was just a modification now. We have some new factors as of 2025.
So the one new factor.
Yeah, but we also eliminated some factors.
Oh, what factors did we get rid of?
Oh God, you're really gonna? I don't know that. I can't.
That's okay.
I can't
We'll get
answer
up
that.
later. But we know they added the new factor about the medical marijuana, and that cannot be an independent grounds to order a drug test against the parent who has the medical marijuana card.
Right.
I didn't know they got rid of custody factors. I'm not sure which ones they got rid of.
There is less. There is less. Well, let's talk about medical marijuana. So, in some states like New York, New York has
It's recreational.
cannabis is legal both recreational and medical. New Jersey, cannabis is legal both recreational and medical.
Florida,
And
it's medical.
Florida, it's medical. Pennsylvania, it's medical. I have most of the courts in Northeast PA I'm finding take a really interesting look at that.
What
They
does
want
that
to
mean?
see the medical marijuana card, and quite honestly, if I have a medical marijuana card and it's not affecting my parenting, and I'm obviously not driving intoxicated under cannabis, and I'm obviously not making, falling asleep at my child's dance recital or making poor parenting decisions, that shouldn't be held against the party.
Do you find that the courts weigh alcohol and alcoholism and marijuana use and maybe marijuana addiction the same, or are they treating those two substances differently?
I think my experience in Northeast Pennsylvania is they really analyze them both very similarly. Is it being abused, and is it how is it harming the children? A perfect example would be you have one party who has a medical marijuana card. However, that party isn't holding a job. That as a result of that, the children maybe aren't having proper meals. As a result of that, during their custodial period, the children aren't getting to school on time. As a result of that, the children maybe have seen that parent be passed out. Those are when you get into the realm of concern. But if you have a parent who has a medical marijuana card and they use it for the ability to go to sleep at night because they have anxiety, but they hold a full-time job, they can function, the children are being taken care of, there is no concern about safety issues, it shouldn't be a factor that tips either way.
I imagine in 30 years you've seen a general trend towards increased use of marijuana because it's been progressively getting legal. Do you see that alcohol use in the family law realm has decreased, or has stayed about the same?
It's interesting that you asked that, because 35 years ago when I started practicing, if you tested positive for a drug test, you were losing custody.
Wow.
Not the case today.
Yeah.
Alcohol, it was harder to prove alcoholism.
It's still hard to prove. I think it's out of your system in like 48 hours.
It's harder to prove.
Less.
Obviously if there's a DUI, obviously if there's an accident, obviously it's hard to prove. I think the courts are looking more at abuse of alcohol and drugs as an illness, which in my opinion, that's what the court should be looking at it. I don't believe that anybody wakes up and says, I want to be a drug addict. I don't believe anybody wakes up and says, I want to be an alcoholic. I do believe that it is an illness. It is an illness that is treatable. It is an illness that you can recover from. And it is an illness that you can take a path that you can be a good parent again.
Let's say you had a parent come in who lost their custodial rights because of alcohol. They got a couple DUIs, then their first custody trial, it came out that they're an alcoholic. How can that parent take proactive steps to regain custody of their children?
That's an excellent, excellent question. So when you file a custody petition, when that custody petition is what's before the court today, what's happening today. So if I had a client who came to me and said, Attorney Klaus, I was a heroin addict and I was on the streets and I was addicted and I went to jail, and but I'm on recovery now and I went through taking methadone and I'm off of methadone. I'd say, do you have a job now? Do you go to church now? Do you go to AA? Do you talk about it? Do you have a therapist? Do you have a support family? And I would go through all the factors, because recovery is consistent, constant, and if the court sees that, the court's going to award them custody. The court's going to say, wait a minute, this person went from the bottom of the barrel, drugs, alcohol, incarceration, and then pulled themselves up and got themselves in a rehab, got themselves help, got themselves to a point where they could get a job again, to a point where they could go to church again, to a point where they could talk about it in support groups, to a point where they're helping other people, to a point where they have a life and a family that's supporting them now. Because most of the time when you're down here, you have to really hit the bottom. They don't have all that. The court looks like that and they want to cheer and they want to give that client an opportunity to parent.
A parent who lost custodial rights because of drug use. And it seemed to me like you were saying that, and correct me if I'm wrong, the courts will look at the custody factors and compare those to the situation before to show how they've changed now.
Well, one of the factors is a history of drug or alcohol abuse. Okay. So when I'm representing a client who is recovering and on a path where they are back to who they want to be, I choose to bring it right out. I start right out and say, Mary, let's start out and tell the court, you were incarcerated for drug use. You lost custody. Tell me where you're at. Where did you go to rehab? How long were you in rehab? What did you learn at rehab? What did you do after rehab? How many bridges did you burn when you were a drug addict, and how did you build those bridges back again?
Yeah.
Where are you at now? Do you have a job now? Tell me about your family. Tell me about your support staff. And I normally have them all in the courtroom.
Yeah. Have you read the book Eat the Bruises?
No.
It's because it's so funny you say you just bring it right out. I haven't read the book either, but I think this is the premise of the book. It's a trial book. And the idea of eating the bruises is when you get an apple, it's bruised.
Mm-hmm.
Most people eat around the bruises. And the principle of that book from a trial strategy is the defense is going to bring out all those bad facts. You have the first opportunity to bring them to the court, to bring them to the jury, and present them first. You might as well present them first. But, in the personal injury realm, a lot of times the defense will blow up the medical records and will show a little line, a single line in the medical records will show full recovery. And so rather than presenting your whole case about how injured your client is and how, she's not recovering, you just show that to the jury. You usually pull it right up in front of them so that you cut the defense off. You ate that bruise and kind of pull the rug out. And so in the custody realm or in the family law realm, it's funny that after 3 decades of experience, you, without reading the book, you figured out, let's just show that to the judge first, rip the Band-Aid off, and keep moving forward.
I've always been of the opinion that in a custody case, we have to take a canvas and I need to paint the whole picture of my client. The past to the degree that it's relevant in the factors, the good and the bad, and the current. And with the proper analysis of the facts, you can do that well and help your client be successful in a custody case. One of the things is the clients do need to be truthful with an attorney. The reason they have to be truthful is, I had a case. I'll give a perfect example. I had a case, client says, yes, I've shared everything with you. It was a PFA case, and the client wanted to defend the PFA case. And he happened to be at work, and we could prove he was at work because there was a clock in. So we had the person with the clock. We were ready to testify. And then the incident comes up. There were 2 incidents. One we could cover because he was at work, and then there was a second incident. And the client says, he told me everything. It definitely didn't happen. And this was like very early on in my career. And I remember the spouse gets on the stand and the spouse says, he's really a nice guy, except when he comes home and uses heroin. And I never forget, the judge looked at me, pulled his glasses down. I said, Your Honor, may I have a break? Yes. And I went and I said to the client, did you forget to tell me something? He goes, well, I didn't think she was going to bring it up because she does it too sometimes. I'm like, oh, I think we're going to have to agree to a consensual PFA without an admission of fault or allegations.
Yeah, I don't know why, because this is what I tell all our clients, is it goes to our grave. You have to tell me the good facts and the bad facts so that I can protect you.
Right.
If you don't tell me the bad facts, I have to prepare on the spot, which is not going to be beneficial for you, because if we can prepare ahead of time, we can come up with a game plan.
But
if something comes out, we're in trouble.
That's one of the reasons I've done the questionnaire. I have a custody questionnaire and a divorce questionnaire because I want to get them thinking about telling me everything and what I'm going to be looking for. And I think the repeated meetings helps because we all don't want to talk about our dirty laundry.
It's personal. Yeah.
However, in family law, we need to know about the dirty laundry.
Yeah. We
need to know about everything to do it well.
I think especially in family law, because the other side's going to use it.
Mm-hmm.
They're going to use everything they can to try to get custody or get the one-up on the divorce, to get the lake house, so to say. But if you don't tell us those bad facts, we can't try to minimize them later, and we're left pivoting on the spot or entering into an agreement that, should he have told you that ahead of time, I imagine you could have ate the bruise.
Yeah.
And just brought it out and dealt with it and then pointed out that she does it as well. So maybe the court would consider it a moot issue.
And I think what's important is sometimes if they don't share that fact as a lawyer, at least for me, it's hard to not show my reaction. I try not to, but when I see something, I just had a case recently and there was a photo of stuff thrown all outside the window. And I knew that there was an issue of infidelity, and I in my mind, I thought that that was probably my client's reaction to the infidelity. However, I wish I would have known that there was that photograph with all of that stuff thrown outside, because I would have been able to prepare better for it.
Does cheating and infidelity have anything to do with custody?
Nothing at all to do with custody.
But it does play a role in divorce.
Fault ground divorce, for instance, adultery, is only relevant, it's a factor in whether the court will award alimony or not. Sometimes it's very hard. I have a client who comes in and says, I want a divorce and my spouse has been cheating on me. It's very hard for me as a lawyer to have to tell them that someone being unfaithful is not a factor in equitable distribution, dividing your assets equitably. And a lot of times people come in and say, oh, well, it's 50-50 in Pennsylvania. And I have to say, well, we're an equitable distribution state, which, just like custody, there are equitable distribution factors. Husband's age, wife's age, husband's health, wife's health. What did wife do during the marriage? What did husband do during the marriage? Who preserved the assets? Who dissipated the assets? And if you go through all the factors and it's even again, it's 50-50. But if it's not, the court could deviate. The court could make a different determination, 55-45. However, one of those factors is not infidelity. However, in the request for alimony fault grounds is one of the factors to be considered. But I've had cases where a client's gotten short-term alimony and there was infidelity. I've had cases where the client hasn't gotten alimony and there wasn't infidelity. It's, again, a factor analysis. What surprises me is that sometimes, in our practice, we will have an opportunity to get a client from another firm, another lawyer. And it surprises me at the point of, the divorce has already been filed and no one's reviewed the divorce complaint with them. There's an answer and no one's reviewed the answer with them. And then I sit down to talk about the alimony factors and the equitable distribution factors. And they're like, what are you talking about? That surprises me. I think as lawyers, those factors, just like in custody, we need to talk about in the beginning. And then build on them.
Well, when I first got my ticket to practice law, I don't know who told me. I don't know if it was an ethics professor. I don't know if it was you or someone. Someone told me that the two most common reasons attorneys get in trouble with the bar, which is, our license to practice, is number one is trust accounting. You mess up the money. You mess up the client's money. You put the money in the wrong fund. You don't give the client what they deserve.
Simple rule. And don't touch the client's money.
Don't touch the client's money. And then number two was not communicating or failing to communicate with the client. I think the law school example is they had a client, they didn't talk to the attorney for 6 months because the attorney didn't reach out. Simple, especially in this day and age, it's so easy to send a quick case update email, every once in a while, even with the client who says, please don't send me, constant updates for billing purposes. Do you think that's the most common reason people switch attorneys, is their attorney fails to communicate?
I do think that. In my opinion, I don't believe it's what an attorney charges. It's the client wants to be heard. The client wants to know what's happening. The client wants to be explained the process. And if that doesn't happen, then they're leaving the client. The client's leaving the attorney. I have to say that in my practice, I really do try to make sure the client's aware. I put it on my calendar to give them an update. If I have a client who says, I don't want to do anything, I want to step back, I'm making sure I have an email to confirm that they've wanted to step back and they don't want to move the case forward. But in my 35 years, I don't profess to be perfect. And I have a pencil in my office, and I often say to potential new clients, they still make pencils with erasers.
For a reason.
And if you think that you're hiring my firm, me or my son, because we're perfect, that's an illusion. Nobody's perfect. I've made mistakes practicing law, but when I do make a mistake, I call the client immediately. I correct the mistake, and I've never lost a client for making a mistake.
That's like when I talk about guarantees. They always want, what's going to happen, or they want predictions for the future. And I tell them, and I say this every time, I love it. I say, if I can make you guarantees or predict the future, I would be retired, my mom would be retired, there would be no practice of law. Because I would just predict every case, all of my clients would be thrilled, and I'd be done. that would be it.
And it's
Because it just doesn't work that
And
way.
it's so funny that you say that, George, because after a trial, people will say to me, "What do you think?" And I have learned, because sometimes you have like a simple case and you're like, "Oh, I won that," and then surprisingly you get the order and you lost.
Yeah.
And then you have a difficult case and you're like, "Oh, this is a difficult one. I could see really how the judiciary may have some issues," and then you win, or there's a split decision. Or I have learned a long, long time ago, I am not going to guess at what is in a judge's mind. And what I basically tell a client is, we have presented the facts the best that we can, and now we have given it to someone else who's going to make a decision. I will never predict. I've learned my lesson many times over. Do not predict what the judiciary is going to decide. You're not a mind reader. What you want to do is you want to make sure your client's prepared. You want to make sure your client has all the facts, that at the end of the day they say, "I was heard, I got to present my case." I actually just had a custody case a couple weeks ago, and it was a difficult case. A mother had lost custody and she was fighting to get custody back, and she had left another law firm to come to our office. And unfortunately, at this stage, she had never heard about the custody factors. Nobody had went through them with her. I was able to guide her through the factors. I was able to help her present some points to the court, and she did very, very well. And at the end of the case, she said, what do you think? What's going to happen?" And I said, "You did very, very well." And I said, "Now the judge has to review the custody factors, and I couldn't have asked you to present any better, so we'll have to see." And the judge did recognize the significant changes of the client and maintained shared legal custody. The father still kept custody, but she extended the client's custody significantly, giving almost the whole summer, all of the holidays. And the client, of course, was disappointed because she wanted to have primary physical custody. And I said to her, but this was a big step. I mean, she went from having the child one weekend in June and one weekend into July to having the child now all of the holidays of the school year. Anytime that there was a Monday off, she was now going to get the Friday, Saturday, Sunday, Monday, and having all summer. And I said, and acknowledging there's still work you need to do.
Yeah.
There's still work that you need to do, and do it and we'll go back. And so, but the client did very well. I was very happy with the testimony.
Do you find that co-parenting gets easier as the children get older, or harder as the children get older?
I think that depends on the child, because sometimes there's a saying, time heals all wounds. And sometimes, the separation is really rough, and, it's like putting salt in the wounds, and they're nitpicking all the little stuff. And then mother moves on, father moves on. The people that they move on with are great step parents, and the children are very articulate, and then the co-parenting becomes easier. However, when the facts are different, if the mother or the father makes a poor choice on a new partner, and that new partner is not a good stepmom or dad, or the children now have issues that the parents are having difficulty with, then I find that co-parenting becomes heavy as well. I do like when you recognize that there's tension between the parties, a parenting app is helpful.
Yeah, and the course order the parenting apps often.
Yeah, and there's a lot of them that are free now. I mean, I hate to have to spend money on.
Yeah, like Family Wizard.
Yeah,
I think App Close, on another case we had in Monroe County, is free as well. And they have paid versions, but they can use the free version.
Right, and for a while until things settle down, I think that's.
I think it's great because it gives a level of both judicial and attorney oversight. Knowing that an attorney is going to read the text message, or a judge is going to read the text message, should theoretically tone down the conversations between the spouses or parents, so to say.
It's interesting because I'll often have clients bring in text messages or emails between them.
Often.
And then I'm looking at them, and my first comment is, would you like to be spoken to like that? And like, I see things like, well, they'll say my child, or you will, or and I say, wait a minute, it's our child, and maybe you want to make a suggestion. And I always say, first of all, is that how you would like to be spoken to? Do you react well to that tone? And then the second thing I always tell everyone is that with all the social media that's out there, your text messages, your email, your Facebook, your Instagram, your LinkedIn, any
Whatever it is.
it's going to be looked at by the court.
Yeah.
So make sure that what you're doing, you want people to see.
Yeah, we learned in law school that whatever you put in an email, you need to pretend it's going to be read by a judge.
Yeah.
And then we had it happen. You know, we have cases where you don't think an email you sent to opposing counsel is going to come out, and opposing counsel is like, that's exhibit 1
Yeah.
in whatever the motion for relief is.
It's interesting that you say that, because when I started practicing law,
There was no email.
there was no email. There was no computers.
You started on a typewriter.
We had a typewriter.
Ridiculous.
And and you made a mistake, you had to retype it, so you were very careful that you didn't make a mistake.
That's crazy.
And the practice of law was different. I really believe it was slower because clients had to call or come in.
Mm-hmm.
Today, the practice of law is so fast.
Yeah.
You know, they send an email and they expect an instant response.
Yeah.
And
Because they think it's a text message.
right,
People
well, they
text.
send, some people text too.
Well,
but
I don't text clients.
but
Unless they're personal injury, no texting the clients.
But what I try to explain, especially in a big practice, is my emails come to one computer.
Mhm.
My staff then prints out the emails. They go and get the file. They bring the file and the email up to me. So then I review the email. I review the file. I then dictate, because no one would want to pay me to type. Unfortunately, I'm still a bad typist. I dictate, then I review it, and then the staff will send it out. And so the technology, while it's great, I think has broken down a little bit of the personal exchange.
Mhm.
And in family law, in divorce, custody, factual issue cases, listen, in a breach of contract case, it's the contract, we're interpreting it, maybe not as important.
Yeah.
But that interaction is invaluable.
Well, and in the court, because it's never a jury trial in family law, is going to make instantaneous judgments about that person that's sitting there that day.
Yeah.
What is their demeanor? What is their character? Are they sitting there like this and scoffing every time the spouse is on the stand, or are they engaged and humbled by the whole experience because now they've been brought all their dirty laundry to the court because the party's going to come to an agreement? Why don't you think they come to an agreement? Because they can settle anytime.
Well, it's interesting because recently I've been in court a lot, and I look back at it and I say, am I not doing my job? Because I really believe that there is no one who knows a child custody case or a family law divorce case better than the mother and the father, better than the husband and the wife. And good lawyering is getting the facts, getting all the information, and then writing proposals, saying to opposing counsel, let's sit down and try to address this. But lately, and I don't know, maybe it's just something in the
air.
The air.
fall season.
Everything seems to be so adversarial. Like we just agree to disagree. Literally the other day in court, I had opposing counsel say, I'm going to pay for the drug test, and then try to tell me they didn't agree to pay for the drug test. I'm like, I can hear.
Yeah. This is what I tell everyone. And this is why I became a lawyer, was to get to court.
Right.
But litigation is great for lawyers.
Yeah.
Lawyers. It's great. We have to prepare. I have to prepare you. We have to go to trial. The pressure is on. We get to perform. It's why we probably became attorneys. It is not great for the parties. Now a third party, the judge, is going to decide your case when you know it better. Your spouse knows it better. Maybe we enter into an interim agreement that's not good for you. It's not good for them. But at least you get to decide the facts of your case. And I found the same thing too, where maybe one of the parties is willing to agree, but that's only half of the picture.
Mm-hmm.
I could have the worst client, doesn't want to agree to anything, no matter what is proposed, doesn't want to agree, and then the other side comes with agreements every other week, and vice versa. We have a client who says, put together the property settlement agreement, put together the custody agreement, we send it off, and it's reasonable, and the other side doesn't want to agree. Maybe it's fall.
You can't, and the problem is you can't force someone to agree.
No.
You can, what I've found is make a proposal, provide all the supporting documents, Family law shouldn't be a trial by surprise. Provide all of the documents that support. Ask for a sit-down meeting. Try the sit-down meeting. And if it doesn't work, you need to basically be able to say, we're going to court. I mean, I like to go to court. However, I will tell you that, Friday I was in court for 2 different family law cases. It's exhausting as a lawyer. First of all, the preparation. I even after 35 years, I'm like reviewing even moments before. I'm representing someone, and I'm hoping I get all the facts and make sure I convey everything accurately. You really need to be on the ball. It's not a time that you need to have your morning coffee and had your breakfast, and you need to be prepared to present all of that. And at the end of the day, when you're done, it's like,
yeah, you're exhausted.
You're exhausted.
Yeah, you're exhausted because you have to internalize those facts while knowing the law, understanding evidence and objections, and balancing all of that at once. I do the same thing where I'm a big audiobook. I like audiobooks.
Yes.
And I usually listen to my audiobooks when I drive. But if I'm on my way to court, I found that if I put the audiobook on, I don't remember anything that's on the audiobook. Because even on the way to court, I'm thinking about the testimony, I'm anticipating the objections, I'm anticipating the argument. I don't even listen to audio. If I'm going to court, it's just some light music because I know I'm not going to listen to anything that's being said.
It's interesting that you say that because after 35 years of practice, I say, when is that, I don't know,
Butterflies.
that butterfly feeling going to go away? And I realize now that I hope it never goes away.
You care.
Because because what I'm finding out is it's such a part of me, and I really do care factually for my clients, that's what the butterfly is about. And so sometimes I'll have a client come in and they'll be like, they're bringing their children now for me to represent them, and they'll be going to be retiring. When are you going to be retiring? And I said, the first day I come to my practice and I don't love being here, I'll retire. But I love the practice of law. And it doesn't mean that I don't have bad days. We all have stressful factual situations, stressful clients. But the practice of law to help someone through one of the most difficult times in their life, to be able to help them be their voice, it's just part of me.
What do you think was the most stressful custody case you've had ever? Whether it be complexity of facts, complexity of issues, difficulty with opposing counsel, difficulty among the parties. Is there one that stands out?
I will tell you that early on in my career, family law cases were more difficult because they were a less popular issue for the court. And the judges who heard the cases 35 years ago were not as keen on hearing family law matters and not as compassionate. I will tell you that practicing law in Northeast Pennsylvania, Wayne County, Pike County, Monroe County, Lackawanna County, Luzerne County, Susquehanna, Wyoming County, Carbon County, the judges are really, they're on the top of their game. They're listening to facts. I mean, I've had judges from the bench say, I'm going to listen to your family law, but there's no one who knows your case better than the two of you. They're kind, they're considerate, they're recognizing the elements of a custody case. They're realizing how important this is to the litigants, and it is so refreshing. It is it's really a great time to be practicing family law.
Yeah, so to turn it back to the question, we'll pretend it's a deposition.
Okay.
You didn't answer the question.
Okay.
So that's a positive transition, over the course of, the 1980s to today, where the courts are taking family matters more seriously because it's not that, contract dispute for millions of dollars that the judges care about to, progress in their careers. Because family law, I like to call it, we're getting down and dirty, because we're learning the worst facts about the parties, and then we're using those facts to help our client, and the other side's using them to hurt our client. But is there one case that stands out over your career that was memorable because it was tough?
I think that when there is domestic violence that has negatively impacted the children, or when the children have been subject to domestic violence, those are very difficult cases. And one of the probably most difficult cases that I ever had was I represented a party who was the perpetrator.
Mm-hmm.
And it was a very hard case for the children, for that person, for the recovery. And it was, everyone deserves to be heard. And that was probably when children and youth gets involved, and oftentimes people call children and youth for things that children and youth shouldn't be called for. I had a case recently where someone called children and youth because the kids were outside barefoot. Well, I was barefoot June, July, and August whenever walking outside,
Yeah, when you were a kid barefoot and naked and it was normal.
Exactly. So there are times that children and youth should be called, but unfortunately there are a lot of calls where false alarms, and so the false alarms are less concerning. But when there is violence that affects the children, they're difficult cases.
In this day and age, 2025, let's just say theoretically a client came to you, and I'm just making this up on the spot, and they had a history of abuse, let's say maybe 2-3 years ago with the children, and they come to you and they admit that and they become a client of the firm. Can they come back from that?
Yeah, I mean, listen, the law is very forgiving. It doesn't forget, but the law is very forgiving. And I don't do criminal work, but think about someone who violates the laws and is convicted of a crime. They get their punishment and then they've paid their debt to society. And so family law, if I had a client that was honest with me and said, Tammy, 3 years ago I was involved in domestic violence, and this were the facts, and they shared the facts, and I would say, well, what have you done? You were incarcerated for that. What did you do? What did you do in jail? How did you become an outstanding prisoner in jail? What have you done since you've gone out? Have you, what is your work history? Who are your friends? Who's your family? What are you doing to recognize that? Have you gone to domestic violence? Have you spoke at domestic violence? Do you treat with a psychologist or a psychiatrist? How will you handle your temper now? How do you react? And I think building on that, because are there cases where maybe someone is, cannot be redeemed? I hope not.
Yeah.
I hope not.
Yeah, we hope the best.
I hope not. I would really hope that if someone made an error, they could recognize it and move forward in a different direction.
Yeah, switching to child support, and I know we don't do criminal law, but I think this might weave in there. Let's say someone had a child support order against them and they failed to pay child support. What happens?
So the first thing is they'll get a notice from domestic relations that they're delinquent. Then they'll get a letter that says, you're a delinquent, and then they'll be brought up before the court for what's called contempt of court. And they can purge themselves, they're found guilty of not paying, which most of the time they are. If there's an order and you don't pay it, that's contempt. And then they will have an opportunity to purge themselves, which means pay a certain amount so that they don't have to go to jail. If they don't pay that, the court can incarcerate them or take away their driver's license. And I always say to a client, if you're ordered to pay child support, you have to pay it. However, what you need to know is, say you're ordered to pay child support and you get hurt at your job. You need to immediately go to domestic relations and file for a modification. And if you cannot work, there's actually a doctor's note that needs to be filled out that says this is your injury, this is the date that you were hurt, this is how long, because then your order will be suspended while you can't work.
Dad and I were talking about support the other day, and Daddy was talking probably about a case from like the 60s or 70s, but he had a situation where someone was dodging the support payments, and the police came for him. They put him in jail, but they let him out because the judge was like, how can he pay for support if he's in jail?
it is a catch-22 because most of the time you need the support. And if you incarcerate the person, they're not earning money, but sometimes they need to learn that lesson.
Yeah.
I don't think the court rushes to incarcerate people, but normally if they've had many opportunities, I've seen contempt of court where someone hasn't complied with a
Discovery order.
not a discovery order, but let's just say someone has violated a custody order, and they were supposed to meet at a certain place and they didn't. I'm not a firm believer that the first violation you file contempt. I'm the firm believer that the first violation, the client should reach out and say, you were half an hour late, I waited, please don't be late again. The second violation, maybe the counsel should get involved. Your client was now an hour late, at the custody exchange, don't be late, be on time. And maybe like the third time, third straw breaks the camel's back, you petition the court and you say, the individual is supposed to be bringing back the child at 5:00. First he was at 5:15, then it was 6:00, and now it was 7:00, Your Honor. And typically the court the first time will give a warning. The court will say, following a custodial agreement is very important. I have found that you willfully, because you remember contempt, you have to show that they willfully violated an order.
Yeah, not that their car broke down on their way to the drop-off point.
Right. Or, there was a storm and it took them an extra hour, but, willfully violated it. And then the first time the court's going to probably give a severe warning and maybe a small fine. The second time, the likelihood is a larger fine. But most of the time then the court's going to say, if you're back here again,
Don't put you in jail.
Yeah.
It's funny that the civil courts even have what I would call criminal penalties that they can put you in jail for a civil violation. And this might be something good for us to end on because what you've played there about the 3-strike rule I think is really important for this question is how do you balance the petty complaints to the persuasive complaints with the court? Because I imagine, you probably came up with that 3-strike rule based off of your experience because that's what persuades the court. You go for one violation, the court kicks you and you just wasted your time, the client's time, and the court's time. Where on that spectrum from petty complaints to, the kids being outside barefoot during the summer to persuasive complaints, the kids being barefoot outside in the winter repeatedly without clothing, and how do you balance that spectrum from petty to persuasiveness with the court in regards to getting the relief sought? Because parents have all these ideas, right? They want what they want when it comes to their children because their children are the most important things in their lives. But how do you balance the petty complaints to the persuasive complaints? Is it just accumulation of those petty complaints? Or is it really a spectrum of depending on the type of complaint and the timing and the circumstances?
In my opinion, it's a spectrum because have I filed contempt for a first violation? If it was a serious violation, I would give you a perfect example. If someone is ordered not to be drinking because they're, recovering alcoholic and client goes to a custody exchange and they're drunk, I basically say not only are we filing contempt, we're filing an emergency petition. They were driving with the child and we would cover both. I mean, that's a serious allegation versus someone who says parent was 15 minutes late at a custody exchange. Then those are, you have to weigh those. I basically recommend to clients that they keep a custody notebook or a custody calendar and write down everything on a regular basis. And if you're writing down something that shocks your conscience immediately, then you should be contacting your lawyer. If you're writing down something that is aggravating you, like 15 minutes late. I mean, I've had clients call saying they were 5 minutes late.
Wow.
I've had clients call saying they didn't tell me about the dentist appointment. And I say, well, you're available to go to the dentist appointment? Could you go to any dentist appointments? I mean, I had one client who literally would never be available to go to a dentist appointment because the client works in New York City and has to leave at 3 o'clock in the morning and doesn't come home till 9 o'clock, and the dentist is only open Monday through Friday. Then the client was reaching out to me saying she never tells me about the dentist appointments. And I say, well, you have shared legal custody. So that means you can contact the dentist and you can get all the information on the dental appointments. But were you available to go to a dentist appointment? And he goes, no. Then I appreciate your frustration that you don't know, but we can close that circle by you just calling and getting the information.
Yeah.
So that's how I handle it.
Just on a case by case, fact by fact basis, and you'll just have to weigh them and tell the client.
And tell the client, when you have shared legal custody, I do believe that while it is really nice if the parties can be considerate of each other and share the information, I often remind clients that information is equally available to you. Go to the school, give them your custody order, show that you have shared legal custody, get all the information from the school. Most schools are very receptive to sending report cards to mom and dad. Go to the family physician and say, we have shared legal custody, please send notes of the appointments, whether with mom or dad, to me. Go to the dentist and do the same thing. Go to your baseball coach and ask for the same thing. I'm not saying that the other parent shouldn't share that stuff. It still is good co-parenting to share, but you can also be a little bit more proactive, which would eliminate some of the stress.
It would probably look good to the court should you want to change in circumstances that you were being proactive and weren't relying on your co-parent for all of the information when you could just go readily get it yourself.
Exactly. I think that that's important.
And it probably demonstrates that you equally care rather than putting all the pressure on the other parent to provide me the medical records and the medical bills and the school reports and the doctor's records or whatever it may be.
Yeah, I often recommend to clients with shared legal custody, and most of the time I would say 95% of the time it's shared legal custody. It's very hard in Pennsylvania to get sole legal custody.
Do you find that when you've advised a client to keep a journal, whether it be a pain journal in the personal injury realm or a custodial journal in the family law realm, that you can only use that to refresh their recollection later at trial, or can you have that admitted as an exhibit?
Most of the time I'm only using it to refresh, because I say to a client, this is your case. This is your life. No one should know the facts more than you. You shouldn't need to have to read off a calendar what happened. This should be facts that you've absorbed that you're able to flow and tell me very easily. I'm not telling you this to make a document to utilize for court. I'm telling you this so that when we sit down to review, we can review it. You become more credible if you can just tell your side of the story.
And I imagine tying it back into that petty to persuasiveness spectrum, which I think is a nice visual, that should they need constant reminders of dates and times and incidents, it's probably leaning towards more of the petty complaints. But if they really stand out, this date, this time, what happened, it's probably pretty persuasive because it stands out.
Right.
And maybe those are the facts that we want to highlight or file the emergency petition on, not the mom was late for the drop off by 7.5 minutes, or mom failed to text that they were running late, or whatever it may be.
And sometimes when I review a calendar with a client, sometimes an issue comes up. I just had a case where the judge ordered 50-50 custody and then talked about the kids going to school, but the kids were already enrolled in mom's jurisdiction and dad was in another jurisdiction an hour away. And at first blush, I was like, oh my God, we're going to have to file a motion to modify that. And then I reached out to opposing counsel and I said, listen, the children have been going to Western Wayne for 5 years. And while you have your custodial period, you're going to have to bring them up to Western Wayne and bring them back. And opposing counsel agreed.
Otherwise, we'll need a whole relocation proceeding.
Right. Opposing counsel was like, we absolutely agree. My client acknowledges that he's going to be driving from Milford to Western Wayne, and we were able to just address that through a consensual modification.
How does relocation work?
So relocation petition, so first you have to file a notice of relocation. You have to serve it on opposing party. Opposing party has an opportunity to oppose the relocation or agree to the relocation. If they oppose the relocation, then you must file with the court a petition for relocation. And then there is a hearing on whether the relocation is in the best interest and welfare of the child. And there has to be a determination. Why are you moving? What are the benefits to the move? How is it benefiting the child? And how are you going to be making up the custodial time for the parent who would be losing periods of custody because of the relocation? And what I often like to say is, if the Wallenpaupack School District, for instance, is very vast. We have southern Newfoundland and we have northern Hawley, which at the end could be 35 minutes apart, but you're still in the Wallenpaupack School District. If you're staying in the school district and your time isn't going to affect and your move isn't going to affect the custodial time, then I don't believe, and most of the courts that I've been in front of don't believe that that's a relocation. And I even had a case where a client was moving out of Newfoundland and was moving to Milford, but the client was going to bring the child to the school, take the child, pick the child up, and I didn't think it was a relocation either, because how was it wasn't going to be affecting custodial time. We were still going to be doing everything. But if you're moving from Milford to Allentown, that's
different counties.
And
different
now you
school
want to
districts.
have the child go to somewhere in Allentown, that's a relocation.
Let's say, just for example, 2 examples. Let's say you have a client custody agreement and wants to move to another property across the street, 4 blocks away. Obviously same county, obviously same school district, versus same client wants to move from Newfoundland to the end of Hawley. Still potentially same county, maybe Pike Wayne, whatever the weird lines are. Certainly same school district. Do you still have to notice?
No.
No.
Neither one of those circumstances would I give a notice. It's obviously you still want to be respectful to your to the co-parenting. So obviously you would say, listen, I'm moving from 5th Street to Hawley. Here's my address.
So they know where the kids are.
Yeah, exactly. But you don't. That wouldn't result in a relocation,
so
in
it
my
doesn't
opinion.
trigger the relocation statute.
The relocation statute is when you are going to be significantly changing the child's custody time or school district.
Gotcha.
Yeah.
Can both the custodial parent and non-custodial parent file the petition for relocation?
Yeah, both
So
can.
it doesn't matter.
Doesn't matter. Both parties can.
What happens if a parent relocates and doesn't file?
Oh, that's serious consequence. All orders say if you relocate, you need to file a petition for relocation and you could lose custody. I actually had a case in one of the local counties where an individual moved, took the child for the summer, and then refused to bring the child back.
What happened?
The judge signed an emergency order mandating that the child be brought back, and then that client lost custody of the child until we had a custody hearing, and the judge really chastised. You can't withhold a child, and don't move without a court order.
What happens if you have a custody order and let's say it's shared, but a parent relocates out of state without notifying the other parent? Then what do you do? How do you get the child back to the state where there's the custody order?
Was the parent's move out of state going to affect the child? Like, if in that hypothetical, I just would say
Let's use crazy example. Custody order in Pennsylvania without notifying the parent moves to California. Not the boundary line between, Port Jervis and Milford.
Right.
I'm talking, they're across the country. They didn't tell the co-parent.
Did
and
they
just
take the child to
absconded.
California?
Oh yeah, they absconded with the children.
Oh, then you would file an emergency petition to get the child back. That's like kidnapping.
Do you file it here in Pennsylvania?
Yep.
How do you take a Pennsylvania order and enforce it in California?
There
That
is
was
a
just an
way.
example.
There is a way. I can't answer that. Like
Yeah.
I would have to look up the
Yeah,
rules on
look it
that.
up.
But basically, you would file an emergency petition to get the child back in the state. I think you go to the Pennsylvania State Police. You make a complaint. But I don't really know
And you
the
have to
legal.
probably transfer.
Don't
it
put
there.
that on the tape because I don't know all the requirements
okay.
for that.
You don't have to know everything. That's the fun thing.
I would have to look that up.
That's like when we tell our clients that I don't pretend to know everything.
Yeah.
It's okay when I tell you I don't know.
Yeah.
Because I don't.
I mean,
know
I had one case where a client did that. They actually took the child on vacation and were going to refuse to bring the child back. And I remember we got a court order. I remember we had to.
And they probably brought the child back.
They did bring the child back.
Yeah.
It just took a little bit of time.
Yeah. Well, because you're probably right. It probably does trigger kidnapping procedures.
Oh yeah.
Probably some like blue alert or
there was like a
whatever it
Hague
is.
Convention thing in my client. I remember I had to look up the Hague Convention. I was like, oh my God, I didn't
Yeah, I
even
dealt with the Hague on something else. I forget what it was for.
Well, a lot of times in custody periods, if someone wants to take the child on vacation,
Mm-hmm.
a lot of times the client will want to check to see if they're part of the Hague Convention, because if they're part of the Hague Convention and the parent goes to vacation and doesn't bring them back, you could get an court order, get it in that country and get the child to come back. But if they're not a part of the Hague Convention, that could be a little bit more
That would be
difficult.
an issue.
So I actually had a court deny a vacation to a country that wasn't part of the Hague Convention
Because of the risk
of the risk of the child not coming back.
Yeah.
And the parent who was going was had a lot of family there, and we were concerned,
Yeah, I
a
imagine.
rightful concern.
I think that's good for today.
Very good, Georgie.
That was fun.
All right, I'm gonna go home and make stuffed mushrooms.
Yay.
Yes, and then I'll see you at 5:30.
I'll see you at 5:30.